Good evening. Welcome on into the evening edition of From Day One. We'll pick up where we left off with the subsets competency hearing.
Possible, I would like to have that article or give me that reference again.
Yes, sir.
Your assistant.
The article that I was referring to, and as I said, I read it last night. It's called Integrating Non-Psychiatric Models of Delusion-like Beliefs into Forensic Psychiatric Assessment.
All right.
The author is a Joseph M. Pierre, Pierre, and it appears in the Journal of American Academy of Psychiatry and the Law, online, June 2019.
Awesome. And yes, thank you. But I was going to say too, it also allowed me to look up some information on treatment of delusions, et cetera, that I found very helpful. So I do appreciate being included in this. And if there is anything that I can do, I certainly am willing to do that for the court and for the benefit of all parties involved, including Mr. Farnham.
Thank you, Dr. Williamson.
Thank you, Your Honor.
We've used up quite a lot of time, Dr. Williamson. At this point, I'd be prepared to release him to go about his practice. Any objection? State,
No objection.
defense?
No objection.
Thank you, Doctor. It won't.
Thank you, Your Honor, very much.
Feelings if your cursor makes its way over to the red leave button in the upper right-hand corner there too.
Yes, sir.
Thank you.
All right, thank you.
All right. Let me say this. Before someone would be found incompetent by the court, he has the right to make some presentation, I believe, before the court. So I'm prepared to have that, direct myself to the defense. Is there any such presentation that should be made to the court at this point?
Noting his objection to my representing him, I'm aware that he is objecting, but
did you want to consult with him on that?
I mean, we spoke earlier. He's made it very clear he is not the party here. The birth certificate and the DNA documents are who we are actually discussing. He is not agreeing to be the surety for these proceedings. I think based on Dr. Williamson and the case law, I don't think we have any further full presentation. The case law makes it pretty clear it ultimately resides with you to make an independent finding of whether or not he is competent or incompetent to proceed, regardless of whether or not the parties have stipulated to the report or competency itself. But right. I think Dr. Williamson's recommendation, even in his limited ability to review the case, was
just on my narrow question though, and I'm thinking too about the record of the matter. Is there any other presentation by the defendant or on his behalf that should be put before the court?
I object. I'm not the defendant. I'm accused. I have a question. Is that a maritime flag there behind you, Your Honor?
Okay. Anything else, Ms. Roberts?
Can I reflect on the record that Mr. Silverman refused to answer my question about the maritime flag, and that appears to be a maritime flag? Can I ask the clerk, is this a maritime venue in which we're in? Clerk?
Anything else, Ms. Roberts?
No, Your Honor.
All right. Before I talk to the state, inquire of the state, My impression of Dr. Williamson's testimony here under oath went further than his competency evaluation did. He was more qualified in the written evaluation, given the limitations of his assessment of the defendant. And he seemed to offer a more conclusive opinion as to the defendant's incompetence at this point. So I want to hear your position, any presentation that you would have on this matter.
When I've read his report, not the letter, but the report that followed, I felt that was sufficient on the issue of incompetency. Today, he talked about that he did consider malingering as well, but that he ruled it out and still found that if there's malingering, it could be better resolved at the circle of care, whatever the name of the facility is, but that it was still his opinion that the defendant was incompetent. And he did go through all of the legal steps that he's required to address, which I believed he did in his report as well, maybe not quite as direct and to the point. And I think the only issue at this point is whether the court finds the defendant competent or incompetent. I don't think it's helpful for a defendant who has already, where Dr. Williamson has found him to be incompetent with the delusions of grandeur. I don't think it would be helpful to have him appear at the podium and have a chance to represent his views to the court. I think the additional outbursts that have occurred today, I'm sure are of record, and that is sufficient in and of itself. And I would just ask that the court go ahead and make a decision. I am not asking for a second opinion, and I am adopting what Dr. Williamson has said, both orally and in writing. I might add that what Dr. Williamson didn't have, there was a flurry of extra documents that my office received, both through Your Honor and directly from the defendant, on still more documents, and all of them in the same vein and same word salad that Dr. Williamson used, without logic and without a clear understanding of the judicial process.
First of all, let me address that same point. I would not put the competency evaluation of Dr. Williamson typically into the public record. We're not filing it in the court file, but in the event that there is some later appellate review, it can be produced. Any objection by considering it in this for this purpose in terms of competence, determining competence, Jordan Roberts?
No objection. I think his testimony today elaborated on many of the factors that would have come out in an evaluation had there been cooperation.
May I just say one more thing, Your Honor?
Yes, ma'am.
At the last hearing, where we were, the defendant had taken the fifth and left Dr. Williamson's office. Your Honor had made it clear in the hearing that if he didn't, he could be taken into custody until he appeared for the evaluation. And then all of a sudden, the defendant himself made another appointment and did go for the evaluation.
No, I'm not sure that that's the chronology. I was under the impression that he appeared for an appointment arranged by his counsel. Is that not correct, Jordan Roberts?
There had been an order out there to comply with the evaluation that wasn't originally complied with, so he had a mandatory court appearance where he was informed he will either appear for the evaluation or potentially face contempt of court charges. He then appeared for the evaluation, explained he was invoking his Fifth Amendment rights, which is outlined in the evaluation by Dr. Williamson.
So my point was, if Your Honor would order restoration.
Your position is that he'd understand that?
if he understands
Well,
that
that's-
he could be held in contempt if he does not.
We can cross that bridge when we come to it, if we come to it. That's secondary to the threshold determination of competence. I'll tell you what I'm struggling around with. It was the same question that I asked Dr. Williamson. You have someone who the effect of what they may be doing would be to frustrate law enforcement and obstruct the judicial process.
I object to that.
There is I called it to Dr. Williamson a movement of such persons doing that. And we are perhaps more tolerant as a result of the internet and other cultural acceptance of fringe beliefs, conspiracy theories, other. And I am reluctant to identify in some blanket fashion all of the people in that movement who so respond as incompetent, which in a manner which would then tend to immunize is not the correct word, but it creates a presumption that, or at least an inference, that in the future they would not be competent to proceed in some subsequent case. I don't feel I would, and now let me say this. Dr. Williamson directly addressed that contention, which I illustrated with the quote from Through the Looking Glass. Should I be concerned? That's my question to counsel about that proposition.
I believe that he did address it, and he did make a distinction between all of the other people he had evaluated that had the same sovereign citizen claim. But he also,
I object. I do not claim
but
to be a sovereign
also,
citizen. I object
but also,
to that.
Your
I do
Honor.
not claim to be a sovereign citizen. I object.
Okay, but also, Your Honor, by going to the circle of care, they're going to have more forensic and evaluations that are open to them, and if that be the case, then he will quickly be coming back out. And or if they believe that he has a true delusion and can participate in restoration, we'll know from further reports.
Should I be concerned, Jordan Roberts?
I think, and I know Dr. Williamson kind of touched on, he doesn't apply kind of what they're doing to the actual facts of the case from a legal standpoint. He's aware of the movement and how this is clearly distinct from some of the filings that may happen in those cases. I think I could clarify. I do think that he's right, that this is very distinct from some of the other people who are in fact claiming to be sovereign citizens. Just having reviewed different potential defenses that have been sent to me regarding, a lot of times it's driving while license suspended cases, there's a logical connection from driving, I have a constitutional right to travel. It may not be an appropriate legal defense. It may not be case law that's actually binding or persuasive. It may be something that talks about driving, but it's some IRS tax code that they found. But it has some nexus to, they can't tell me I wasn't free to driving because this talks about driving or a vehicle. There's a nexus to what's going on with them, even if it does not apply. Here, I think many of the filings have made it very clear there is no nexus to the ultimate charge of resisting and whether or not none of this is a defense to the allegations that were outlined in the arrest report. We received a filing this week that the presumption of death has been removed. I think it's very clear there's a distinction between the filings in this case and how they may appear sort of in the sovereign citizen vein, but I just don't think that's the route that was taken here.
The videos that are in this case and multiple officers on scene support a far worse behavior than what you've seen in court or even through the documents. The videos were horrible as to how he acted. And I'm not saying that he's not malingering. You know, it could be maybe Circle of Care can do a malingering evaluation as well as their restoration treatment.
So you don't believe from your evaluation that he's feigning this?
Myself personally, Your Honor, I do believe that he's malingering.
You
However,
do?
I do. But I'm not the doctor that examined him, and I'm not a doctor. And the doctor considered that, and he considered the delusions. And in his professional opinion, he believes that he needs to go to the Circle of Care. And I believe that because of that, I don't think any conviction would withstand an appeal if he's not afforded that opportunity.
Okay. Let me put it in a fashion that's designed not to intrude upon any attorney-client privilege. Would it be accurate to say that there's nothing about your interactions with him or your observations of his behavior that would detract from the validity of the opinions offered by Dr. Williamson?
Based on conversations and stuff that's not available to Dr. Williamson or the court because they are privileged communications, I would not personally hold the belief that there is a false representation in an attempt to just paper the state to death into dropping it. I think that firmly believes in the motions that are being filed. I don't think it's an attempt to get out of anything. Obviously, Dr. Williamson has reviewed many of them. I think knowing, based on further conversations I've been able to have, I don't think this is a mere attempt to get out of the case. I think this is just genuinely.
I want to thank both counsel for their advocacy in this matter, and I'll draw an order. At this point, I'd like to go ahead and continue the competency continue the matter for docket sounding incompetence to 8 a.m. on March 14th. Direct the defendant to appear in person for that proceeding. Please put that in the minutes. It's a mandatory appearance, and that is justified by the factors that I put forth in the prior orders, including but not limited to the defendant writing the word rejected across a notice to appear that he had been furnished, and then directing that back to the court. We'll have an answer by that point. I won't have an answer, I expect, by the close of business today. I want to think it over. Furnish that paperwork to the defendant. Take it under advisement. I'll do the order. That's it for now. Now, let's go back to the list. I know we're running late, but it was unusual to have such testimony during the course of the docket sounding.
Right, so on to the March 14th hearing, but this time we hear more than just the random objection from Ronald, who is still sat in the public gallery, this time with his mother as well as his girlfriend. He doubles down on his arguments, but the judge puts him in his place.
Oh, yeah. Judge. Thank you. I still don't have an answer, Mr. Farnham.
Well, he is present if,
Excuse me, Your Honor, I object. This person appears to be interfering with my ability to contract. This is supposed to be speaking to you.
Yeah.
So don't let it happen again. Would you just please let her know? Thank you. And that this case should be dismissed with prejudice.
It's not that I represent to you. It's not that I haven't thought about it. It's not that I haven't researched what the criteria is. It's not that I haven't done that. All right. Then when's our next docket sounding for the side of the
April 12th.
April 12th? All right. I'm going to continue the case to April 12th. I'll have an answer by then, I assure you. It's a mandatory appearance from Mr. Farnham.
All right, well, if you're going to serve me, you'll have to mail me papers. I don't receive any service in court, and I'm not Mr. Farnham. So you'll have to mail any paperwork to me. Let's go. Let's go there, just continue. Yeah, let's go.
April 12th, 9 a.m.
Say we should leave?
No, ma'am. I would ask that he remains to take some papers.
I just want to know.
Yeah, no, ma'am. He should remain here to get the paperwork.
No, Your Honor, my legal counsel has advised me not to receive any service in the courtroom. If you want to serve me any papers, you're going to have to mail them. That way, we can bring up charges on RICO, charges for wire fraud and mail fraud, because this is getting ridiculous.
Well, let me say this. I caution you.
This is ridiculous.
Sir, I may be issuing a bench warrant if you don't appear.
Can you open this for me?
I'm here specially visiting. This isn't an appearance. This is a criminal activity that you guys are doing. Let me ask you, does this court deem me a U.S. citizen on this particular matter? Yes or no?
he actually don't ask.
But let me say this. Charges can be brought against somebody whether they're a citizen or not.
I just need to know the answer to that question, yes or no.
But I correct me if I'm wrong, state or defense, I'm pleased to hear you. But my understanding is that criminal charges in state court can be brought against a person whether they are a citizen or whether they are not a citizen.
So I'm
And that's
trying to determine
correct.
the nature and cause of these accusations.
And
as
that's
the
correct.
accused.
And the state has the prerogative to file the charges, and the state is not dropping the charges. You're going through a
The
process
state
now
has
for.
been,
Excuse
has
me.
received a bill of particulars.
Excuse me. You are going through a process of competency.
I still do not know the nature and cause of this matter.
Well, you
And I
won't
am
let me
here
speak to let
specially
you
visiting
know.
about
Well,
the
that's
family.
why you
Mr.
should.
Roberts, I'm not talking to you. I just want to clear things up here. Like, for instance, you still haven't answered the question
That's
about
why you
maritime
should be in
flag.
good contact with your attorney. I think one of the beauties of our system is that judges don't really answer questions.
Well, then that's dishonorable. How can you be in honor if you won't accept an offer,
Well, you know,
conditionally or directly?
I mean,
That's honor. To satisfy an obligation that you accept or conditionally accept. That's the definition of honor, and you know that. So if you're not willing to answer the
that's not
question, then
really,
you're going
that's
into
not,
dishonor.
I just don't perceive it
and
to be
you
my
can't
obligation, sir,
dishonor.
to respond further. There's the paperwork. Why don't you take that? Thank you. And you can say it's a public proceeding, and I'm pleased to have you remain, or you can be on your way.
And with that, he walks on out of court. Next time we do get him in court, we'll continue to have him. Until then, thanks for watching from day one. Have a great night.